Please share us your thoughts about the JIT and how it tries to navigate the crime of aggression.
Well, let me begin by thanking the organizers for giving me an opportunity to share my thoughts. I've been enjoying the discussions that have taken place before ours, and I do feel like a fish out of water, not only because of my limited professional experience, but also because of the geographical proximity that everybody in this group shares with the region, and the direct impact that this has in some sense resembles the lived experiences of the persons involved in this. Therefore, the discussions have been extra stimulating for someone like me, who does not have a geographical proximity and can vouch that states in the global south, quote-unquote global south, are not as excited about prospects of a GIT. That being said, I am excited, and I have spent time on a presentation and also a paper on this issue. I hope my slides are visible.
Yeah.
All right. So I'll start with the first overview. I won't spend too much time on this, especially since this audience is aware of so many of the issues that this paper seeks to discuss, but also are just common knowledge. But only to say that universal jurisdiction, which is the heart of this paper and also this topic, is in some sense a global sentinel. It ensures that the perpetrators of these egregious crimes do not find safe haven in the world that we live in, especially through aspects of legal tools such as immunities, which was discussed in this issue, which has been discussed in this conference, in this symposium. But a famous example of this, at least here in the United Kingdom, is the Pinochet case, and the House of Lords, which delivered its verdict in 1999, served as a watershed moment, affirming that individuals accused of crimes of torture, as well as those defined under international law, can be held accountable beyond territorial confines where the crimes were actually committed. Of course, the ICC, under a statute and also under the Kampala revisions, which this paper discusses in depth, is also an important aspect, and serves as some sort of an example which discusses the legal and practical dimensions of applying universal jurisdiction to the JIT, examining the congruency of the principle of investigation, whether it can extend to the crime of aggression or not. The analysis will be founded upon the theoretical underpinnings of universal jurisdiction, which will be then juxtaposed to realpolitik that influences its application. This essay and also therefore this presentation delves deeper into the broader political aspects and the implications, whether they're intersecting at issues of legal considerations or not. Additionally, it will also discuss the mandate, which is also acknowledged and focused on the sharply trained enforcement of the legal feasibility and implications of exercising universal jurisdiction for the crimes of aggression, guided by legal precedent, scholarly debate, statutes, and underpin the international criminal law. Having said all that, it is also important to consider the beginning, and I should spend very little time on this, given that this is, in at least for this group, common knowledge. Universal jurisdiction, which is as a crime and as a principle, is, at least in its beginning, referred to as quote-unquote protective principle, which dates back to the time of Gentili and also Grotius, therefore taking us back to the 16th century. But if one were to fast forward this into the 20th century, we see that the story of jurisdiction creating clearer statutory respect and providence, especially in the Geneva Conventions of 1949 and their additional protocols, which explicitly articulate obligations for the prosecution of grave breaches regardless of where they occurred, laying the cornerstone of the principle of universality in treaty law. The GIT, which this panel but also the entire symposium discusses, is a product of cooperation between several states, namely Lithuania, Poland, Ukraine, Estonia, Latvia, Slovakia, Romania, which form within the auspices of the European Union's legal instruments. This formation was, of course, this is common knowledge to everyone here, formed under the Council Framework Decision of 2002 465 JHA on joint investigation teams, and was further articulated in a directive later on, which formed the European Investigation Order in criminal matters, which is geared towards efficient and effective investigation and prosecution of cross-border criminal activity. In this respect, the contextualization of the formation of the JIT with respect to the Ukrainian crisis, one must appreciate the gravity of the alleged crimes and also the historical momentum towards recognizing the need for a robust international legal mechanism to address such crimes. To understand this, the JIT's actions in a broader narrative of international criminal justice need to be studied and also explored. It is essential to explore how the investigation and the possible or potential prosecutions could harmonize or diverge with the established principles and practices of universal jurisdiction, particularly in the challenging context of the conflict of Ukraine. And this man has played an instrumental role, at least in the creation or also the imagination of international criminal law, who I do recollect once saying that international criminal law and also the court is like a giant without limbs. Make of that what you will, but the contours of universal jurisdiction and also his references to this have posited that it is premised upon an inherent international interest in the application and enforcement of certain universally recognized norms. Of course, the universal recognition of norms is a principle which takes us back not only to the UN Charter and Article 51 and also Article 8 of the Rome Statute, but also the Barcelona Traction case, which highlighted the erga omnes obligations upon states with concern because of the basic rights that entail the collective interest of the community of nations. This is of course significant for further discussions as well, but was the first starting point wherein this concept gained further traction and interest in study. Now, with respect to the national courts and also their interpretations, I will comment upon these, but I now understand that these comments can be articulated better by those in this group, especially given that they represent these groups. And as an outsider, I look at these from a different perspective. That being said, the Lithuanian Criminal Code, for instance, under Article 250, exhibits a comprehensive incorporation of international crimes, including crimes against humanity, war crimes, reflecting also war crimes affecting adherence to its international obligations. For instance, the crime of aggression as defined under the UN General Assembly resolution, which is quoted in the paper and I don't remember by heart, has a nuanced representation that has been further interpreted in the domestic statutes. Poland, for instance, in its Institute of National Remembrance, is also an illustration of the Polish engagement with international crimes, albeit from an historical lens which focused primarily on crimes committed in the Second World War. Estonia also stands as an example for a robust approach to universal jurisdiction, particularly through its penal code, which explicitly allows the prosecution of serious crimes committed abroad, irrespective of the perpetrator's nationality. Latvia is also another example which exercises universal jurisdiction over grave breaches of international humanitarian law, yet it has also adopted a cautious approach in practice, but rarely invoking the principle. And I, to this end, want to thank Professor Martin Paparinskis of UCL, who has written a seminal article discussing this aspect with others. The Slovakian regime also offers an example, so does the Romanian. But while each state has ratified the Rome Statute that subscribes to the definitions of international crimes contained therein, the transposition of these definitions into national law becomes exceptionally important, and even more so given the circumstance that we find ourselves in. Perhaps a slight detour here, but a relevant one, would be the example of ecocide, which has also found lots of significance within the domestic regimes of Eastern Europe and the former USSR states. Lithuania and also Poland offer an approach which is comprehensively adopted of the international definitions, whereas Poland and Slovakia have offered a more selective approach to its adaptations and also understandings of these laws. Of course, the common thread between these states is the former USSR, but Poland, for example, has a tumultuous history which is scarred with the experiences of World War II and the Cold War, has instilled a legal consciousness that prioritizes the recognition and prosecution of historical crimes, This perspective, however, means that legal form of aggression may not be as clearly articulated in its framework. Romania, for example, in its authoritarian regimes, has reflected a vigilant approach to these crimes within their system, albeit with an emphasis on protecting state sovereignty, which can be seen as a careful consideration and codification of the crimes, given how it can turn upon itself. The analysis, therefore, of these member states and their legislative tapestry offers an approach to domestic crimes and trial of these crimes in their courts, therefore influencing both legal traditions and also historical narratives writ large. The mandate, therefore, of universal jurisdiction and also of the JIT is something that requires further study. Formed under the auspices of the 2000 Convention on Mutual Assistance in Criminal Matters between member states of the European Union, is also encapsulated in a decision by Europol, which facilitates the support and also the strength of the investigative capabilities, which perhaps our chair can also share his experience about with the ICC. The mandate also extends, the mandate of this of the mechanism also offers a realm of extension to carry out international studies on these grave offences such as war crimes, crimes against humanity and genocide. This is of course also bearing reference to what I said earlier in respect to other international agreements and also mechanisms such as the Geneva Conventions, the additional protocols and also the Rome Statute. In this respect, one can also recollect the arrest warrants case, which allows for prosecution of certain serious crimes irrespective of whether they were committed by the national or not. And of course the Gambia-Myanmar case also serves as a poignant example of this example. Of course, this is something which needs to be determined, and the investigations need to satisfy the demands of the principles on which it is created. Therefore, the need for impartiality, due process, and rigorous evidentiary standards as defined under the Princeton Principles of Universal Jurisdiction. An example of this perhaps can be found in the Belgian law on universal jurisdiction, which allows for prosecution of international crimes regardless of the nationality and the location of the accused until its amendment to due international pressure succumbed this mechanism. However, that is not all. The harmonization of these legal procedures and also mechanisms of collective and admissible evidence and extradition processes and the protection of rights of suspects and victims something requires further study. Perhaps another legal example that can be offered is in the example of the United States versus Alvarez and McKinnon, which was the exercise of universal jurisdiction but can sometimes conflict with the rights of the accused, particularly in the context of extraterritorial abductions. This is of course also outlined in Article 20 of the Rome Statute, which prohibits double jeopardy and ensuring compliance with principles of legality in criminal law. Each member's commitment to these principles must be unequivocal to maintain the legitimacy of the JIT's operations under the paradigm of universal jurisdiction. All in all, such an endeavor would not only reaffirm the international community's commitment to combat impunity, but also contribute toward the progressive development of international criminal law. As this field continues to evolve, the role of the JIT will be instrumental in shaping the landscape of international criminal jurisprudence. But what about the principles of protective and universal jurisdiction? These concepts, of course, as I have said earlier, are rooted in history, but also in present day time, and not only in present day time in international statutes, but also in domestic statutes such as those of Romania, which under Article 10 of its Romanian Code provides jurisdiction for offences committed outside the Romanian state by foreign citizens or stateless persons against Romanian security. The Romanian security infrastructure can and has been attacked by espionage, terrorism, cyber attacks, which can be orchestrated beyond the borders of the state. Universal jurisdiction, on the other hand, offers itself as a broader concept. The universal jurisdiction allows any state to claim jurisdiction over an accused person, regardless of where the crime was committed. The protective jurisdiction differs slightly in terms of its aspects and also its application. As I've already shown, that the balancing nature of interest which are protected at the principles of protective jurisdiction, with its obligation towards international justice, presents a unique challenge for states to deal with. The scope of protected jurisdiction is narrowly tailored towards offences that directly impact the state involved in it, and the potentiality of the global scope is therefore kept further and further away. This tension is also evident and goes back to as far as the Lotus case, where the PCIJ recognized the broad discretion between the states applying the criminal law and where the act was committed, therefore creating a legal quagmire which needs to be wriggled out of. What about international entities and institutions such as the Europol, the Eurojust, the ICC, and the evolving role of these institutions, which to my mind can play perhaps the most significant role? Well, in terms of Europol and its regulations, it is more focused on supporting and strengthening action by member states, police authorities, and mutual cooperation in preventing and combating serious offences, and also the member states who are fighting against acts such as terrorism, for which they have been affected by the common interest of protection. Their analytical capabilities, their criminal database, securing strong and secure lines of communication are perhaps the most important ones that they deal with. The ICC, on the other hand, with its Rome Statute under Articles 5 and 17, are responsible for crimes which are of a much more heinous nature and therefore have a much more larger discourse that they need to deal with. However, with respect to Eurojust, the robust framework that it deals with for judicial cooperation can facilitate JIT's endeavour in cross-border legal challenges, providing legal expertise, but also fostering a common need for international crimes and protection against them. But the Europol's capacity for strategic and analytical studies is also something that provides synergy between the Council's decision to establish the JIT. The principle of complementarity also is something that requires further study of the ICC and also this jurisdictional reach. Of course, this is enshrined as a principle under Article 17 of the Code. This principle also necessitates an environment where national jurisdictions, such as those within the JIT's framework, must first assert or relinquish the authority to prosecute. The interplay between the principles of the complementarity and also the JIT in its nuanced approach. What about? Yeah.
Sorry to intervene. I'm trying to keep an eye on the time. You still have some time, but if you could come to a bit of a close. Thanks so much.
This is my final slide. After this, I'll close.
Sorry.
That's all right. What about the established principles and also the politics that the court will have to deal with, given its mandate, given its jurisdiction, given the engagement that it has with the principles of those such as immunities, but also the environment that it finds itself in, the political climate that it finds itself in, and the relationship that it would have, which would require a delineation of prosecution and also prosecutorial prerogatives, ensuring that the investigatory work of the JIT feeds into the tribunal's processes without jurisdiction friction. Of course, in this respect, the crime of aggression needs to be further studied vis-à-vis the United Nations Charter. The crime of aggression, unlike other international crimes, implicates the state's leaders, a facet that is inherently complicated with evidence gathering processes, as it often involves classified or highly protected information. Geopolitical dynamics have also found a profound impact on the operationalization of universal jurisdiction, as was discussed in the panel just before this. The reaction of the Global South, reaction of Latin American states, the South Asian states, African states. It seems to my mind that this is the war that the Europeans, with its American and Australian allies, and a limited number of Asian allies, is fighting against the perpetrator, which is now evidently supported by China, but also states like Iran and North Korea. So that geopolitical dimension will further complicate the creation of a special tribunal, which could be interpreted as a reflection of the international community's lack of confidence in national systems, but also inability or unwillingness to prosecute high threshold international crimes, which could in turn influence the JIT's working relationship with national authorities. The proposal for a special tribunal for Ukraine presents a complex interplay of legal innovation and political maneuvering. Its implications, therefore, for the JIT are manifold, promising the potential for contracted legal action and also posing a significant challenge to collaboration. As the nexus of law follows, the continuous definition of crimes of justice needs to be combated with practical realities. And now to finally close, as this essay has elucidated, or at least I hope to, the confluence of international legal doctrines with national judicial systems through the prism of JIT harbors the potential for a transformative approach to prosecuting the crimes of aggression, an approach that resonates with the clamor of justice across borders and the aspirations of the international community. The role buttressed with international entities such as the Eurojust, the Europol and the ICC has an increasing interest in the salience of its relevance. The principles of jurisprudence of universal jurisdiction, if harmonized, will become important aspects that can have effects on collaborative efficacy and also international crimes and the mechanisms that are available to us. As the arc of legal history bends towards a more accountable and a more just world order, the JIT's role in leveraging universal jurisdiction to combat impunity, and also immunity is something that will become a beacon of hope. And with that hope, I now give the floor back to the chair and thank him for giving me the opportunity to share my thoughts, and also to the organizers, especially Carolina. Thank you.
Thank you very much, Ankit, and thank you also for having the flexibility to stand in. Sorry for my brief interruption, but very informative, very rich. We'll quickly move on and look, the sheet is already there. Mikhail, now the floor is yours.
Thanks a lot.